Yes, absolutely. I have with me the man who has been in the eye of the storm, Speaker of Maharashtra Legislative Assembly, Rahul Narwekar. Sir, thank you for speaking to CNN News 18. The most important question everyone is asking, and since this matter is nationally important, not just politically but constitutionally, is that how is it that nobody has been disqualified?
As you're aware that these disqualification proceedings have been pending before me, in which I have delivered the orders yesterday. In this matter, the Honorable Supreme Court had given certain principles which need to be followed, certain guidelines with regards to how this matter should be adjudicated. So prima facie, the Supreme Court was of the view that it is evident that there is a split within the Shiv Sena political party, and therefore prior to deciding which is the who should be appointed as the whip, who should be recognized as the whip of the party, they were of the view that I should first decide prima facie which is the political party, which group represents the political party, and therefore I proceeded to decide that issue as the preliminary issue. The Supreme Court had laid down a triple test principle while deciding this issue. They said you should consider the constitution, you should consider the organizational structure of the party, and you should consider the numerical strength of the legislature party. And we have considered all these three aspects. With regards to the constitution, I have ruled yesterday that I have to abide by the constitution which is recognized by the Election Commission of India, and that was the 1999 constitution. Thereafter, with regards to the organizational structure also, whatever is on the record of the ECI, I have gone in accordance to that. At paragraph 168 of the order of the Supreme Court has said that the organizational structure should be in conformity with the provisions within the Shiv Sena constitution, applicable Shiv Sena constitution. However, when we compared the constitutional provisions and the organizational structure which is on record, it wasn't in conformity with that, and therefore that could not be considered as the basis of deciding which is the right political party or which group represents the political party. Even the constitution was silent with regards to how this dispute is to be resolved, and then we were to finally look at the strength of the legislature group, and based on these criterias, I have decided that Eknath Shinde fraction is the real Shiv Sena, and based on that, as the Supreme Court had directed that you have to respect the desire and the will of the political party while deciding who is the whip of the party. So I had no option but to recognize the desire of the political party, which I had already ruled is Mr. Shinde's faction, and accordingly Mr. Bharat Gogale was recognized as the whip as on 2022 June. And after deciding that, I had to ensure that all the principles of natural justice are also followed. I had to see that the whip which was issued by Bharat Gogale was adequately and rightly served upon the members belonging to the Uddhav Thackeray faction. However, the whip that was issued, there was no evidence of it being served adequately upon the respondents, that is the Uddhav Thackeray faction MLAs, and therefore in view thereof I could not hold that the MLAs of the Uddhav Thackeray faction have voluntarily disobeyed the whip issued by the party, and that is the reason why you have seen the order which I have passed. And see, there are various layers and filters which need to be passed before you decide the disqualification of a particular MLA. You have to see whether the whip has been issued by the appropriate authority. You have to see whether the appropriate authority had the jurisdiction to issue the whip. You have to see whether the whip, after being issued, was served adequately and properly upon the respondents. So I have gone through all these layers. I have considered all the provisions which I have been asked to consider by the Honorable Supreme Court, and keeping in mind the provisions of the Constitution of India under the 10th schedule, keeping in mind the rules regarding disqualification of the Maharashtra Legislative Assembly and the guiding principles and guidelines given by the Honorable Supreme Court, I have taken a decision which, to my mind, is a legally tenable and sustainable decision.
So this is the first time you're putting on record after the verdict about what was the reasoning, especially with respect to the biggest doubt as to how is it that none of them got disqualified. Today we are seeing protests against you on the streets of Mumbai. Black flags are being waved. It's being called that the verdict that you gave was indeed match fixing, that you will have to now go to the apex court where Uddhav Thackeray faction of Shiv Sena is going to approach again. How do you look at these developments?
Well, I think first of all it is very unfortunate that a serious proceeding like the defection petition, which decides the fate of public representatives who have been elected by an electorate of at least 3 lakh people, is being considered to be a match. Needless to say, there is absolutely no fixing. I am not here to satisfy the desires of an individual or a group. I am here to uphold the values of parliamentary democracy. I am here to ensure that the provisions of the Constitution are rightly interpreted and implemented. Therefore, if someone has a grievance with regards to the decision that I have given, there are forums to redress this. They can approach the courts. There is no stopping. Every citizen of India who feels offended with regards to any fundamental rights being encroached upon can approach the Supreme Court under Article 32 or the High Courts under Article 226. And the fact remains that just because you approach the court, that does not justify your case. You to set aside an order passed by an appropriate quasi-judicial authority, you need to express and justify and have a proper reasoning. To my mind, the order passed by me is completely sustainable under law and is based on sound principles of jurisprudence established in this country, more so in accordance with the 10th schedule and the rules in this behalf.
So the verdict that you have given is important, not just for Maharashtra, as I said, but nationally, constitutionally as well. It has implications. You know, what you spoke about, at least your interpretation with respect to the chief of the party, what happens if democratically the party leaders have a different opinion than the chief, will have long-term implications as well. How do you see these implications, particularly at a time when one split is behind you, but another split is again in front of you? The NCP is continuing to, hear the matter in front of you. So how do you see that interpretation affecting the political discourse further?
The very reason why the Supreme Court had asked me to look into the party constitution is because normally the party constitution provides answers with regards to who's the final decision-making person in the party and how a decision is to be taken within the party. In the Shiv Sena constitution that I perused, it's clearly stated that although the Shiv Sena party president is the superior most post within the party, the superior most decision-making authority within the party is the Rashtriya Karyakarani, which is the national executive. And therefore, for such a decision to have been taken, it required the nod of the Rashtriya Karyakarani. There was nothing on record to establish that the Rashtriya Karyakarani had given such a nod. To assume that the will of the president of the party reflects the will of the political party is rather dangerous to my mind, because in a scenario where a president defects, does that mean that the entire party will have to defect? Or if the president has a different view and there is a dissent with regards to the rest of the members in the party, does that mean that the president, based on his will, can destroy or perhaps demolish and bulldoze the dissent within the party? This, of course, is against inter-party democracy and certainly not in accordance with the constitutional provisions. And therefore, I have explained this in my order as well, and I am sure that a clear reading of these provisions will leave no doubt in anyone's mind with regards to the fairness of this order.
What will be the course of action now for you?
Well, I think the course of action from my end is over insofar as this petition is concerned. But as I have mentioned earlier, that the Schedule 10 and anti-defection law in this country is perhaps the core of existence of parliamentary democracy in this country, which has to be taken up very seriously. And it has been my endeavorance to ensure that the decision that I take is supported by strong principles of in this behalf, and they have been justified. I feel that the parliamentary democracy in this country and the Schedule 10 and the provisions for anti-defection is an evolving law and evolving system. It changes with changing situations. The law that existed about 15 to 20 years back, a decade or two back, was way weaker than the law that we see today. The deletion of the third para 3 of the 10th schedule, the provisions with regards to split and merger have been introduced in 2006, which has made this anti-defection law much stronger. For the first time, the courts have asked the speaker to decide which is the political party when the cause of action arose. And therefore, there are some new facets to this decision which weren't seen in the past. And therefore, I feel that this decision will perhaps settle the law with regards to various issues which were inconclusive in the past with regards to defection in this defection law in the country. So I hope that this is taken in the right spirit. Of course, in democracy, you're open to a deliberation and a debate. You're open to arguments. You're open to dissent. And if there is a debate on this issue, I think it should be welcomed by all, because this will only strengthen the position of law in this behalf.
So there's just one last question, something that needs to come on record with respect to your decision about Sena versus Sena split, and that is about the constitution of the party. Videos are circulating on social media showing the proceedings of the 2018 National Executive Meeting of the Shiv Sena, saying that that was the valid point, or that was the meeting which should have been taken into considerations. Questions being raised about how is it that you took the 1999 constitution and not the 2018 National Executive Meeting into consideration?
See, it was the very argument of the petitioners in the case, which was the Uddhav Thackeray faction, that there should be a prima facie decision. And the court's order were also very clear that they require me to take into account the constitution which is on record submitted to the Election Commission prior to the dispute. I have made inquiry. The stand of the Uddhav Thackeray faction was that the amended 2018 constitution should be taken on while deciding this issue, and the Shinde faction said that the 99 constitution should be taken on record and considered. However, there was a dispute between both the parties with regards to which is the applicable constitution. In such a situation, the courts have clearly directed that I am required to take into account the constitution recognized by the Election Commission of India. I have written to the Election Commission of India. They have replied to my letter saying that the 1999 constitution is the only constitution on record with the Election Commission of India, and there is no other constitution which they recognize as on date. With regards to the 2018 allegedly amended constitution is concerned, which it is not on the record of the Election Commission of India. Therefore, I am not required to take cognizance of it in accordance with the ruling of the Honorable Apex Court. So I think this answers the question. Whether there was a meeting in 2018, whether there was a resolution passed, is all academic in nature. If the Election Commission does not recognize it, there is no reason for the Speaker to recognize it.
So on that note, thank you so much for speaking to CNN News 18. This was Rahul Narwekar in an exclusive conversation. Several key points in that important interview, the most important one being germane to the developments that are happening in Maharashtra right now, which have far-reaching implications politically and constitutionally, particularly the NCP battle, the averments that he has made, or the observations that he has made with respect to what is the stance that the party leader takes, the party president takes, and what if it changes against the stance of the other party leaders. With video journalist Vasant, this is Vinaya Deshpande from Mumbai.